Morning, everyone.
Morning.
Can everybody hear me okay? You guys successfully avoided the first row of seats. That means our late arrivals will be cursed with the front row. But it's good to see everybody. It's good to see everybody online, although I can't see you, but I know you're there. It's good to see people in person. It's fun to come out and talk to actual humans. I know it's been a couple of years, a couple of long years. So every time we get a chance to do this and then meet with our clients and our friends in the industry, talk to them, shake hands, it makes for a different experience. And I know it's a pain in the butt to get down into the city and get parking and come here. So we appreciate everybody for coming out. We appreciate everybody for signing on as well. You're taking time out of your busy day. So thank you, everybody. My name is Jason Hanford. I'm a partner at Chartwell Law. I practice primarily and almost exclusively now Pennsylvania workers' compensation. I've dabbled in the past. I've learned that dabbling can be dangerous. So PA work comp is what I do. It's what we'll say love. We use the word love today. So we're going to touch on a variety of differing topics that are reflective of life in our industry. We're going to talk about what everybody experiences in life. We're going to talk about death. Lee's a cheery guy and wants to talk death. We're going to talk about drugs. And we're going to talk about what everybody's excited about, pharmacy bills. So we're going to touch on some other topics. Everybody sent us some really good questions. We originally planned this as an Ask Me Anything presentation. I think people were confused. They didn't know what that was, but we want it to be a give and a take. So if you have a question as we're talking, please interrupt us. Please raise your hand or just shout out or throw your basketball at us. That would be fun. It is, in case you weren't aware, it's March Madness season. It's basketball season. So we obviously incorporated that into our theme. You can see it on the slide there. You can see the basketball on your table. And the other thing we're going to do, I think you'll see in the middle of the room, there's a bracket. So we're going to try to, thank you, Lee. We're going to try to incorporate that into our presentation. And the way we're going to do that is, as I navigate here, we're going to have everybody get the opportunity to choose a team. So if you're familiar with the bracket and have it memorized, good for you. If not, it's right in front of you. If you've never done this before, it's fun to pick the low seeds and be a hero. Go for the chalk. Pick the 1 or the 2, and we'll record everybody's choices. We got stickers with your name tags. The way you get your name up on there is you interact, you get involved. Apologies to the people at home on the computer, but this is the in-person aspect. So if you answer a question, if you just say hi, if you smile, we're going to get your name, we're going to get your name tag, and you're going to pick a team. So again, I encourage you to start with the 1s, but you can pick whatever team you want. So we'll track all that. Obviously, the tournament's not over today, but when it is, I guess whoever makes it the furthest in the tournament, or if you win, they get a handsome prize, right?
Yeah. What is that prize, Jason?
It's handsome. The prize will be handsome. I don't know that, Eric, have we determined what the handsome prize is? That's how exciting it is. We can't even tell you, but you will win the handsome prize. So keep involved. Ask us questions. I think we'll have some questions to ask you, and just talk to us and you might win the whole darn thing. Logistics. We have bathrooms. So if you're one of those persons that uses a bathroom, not online, you can use your own. You're going to go out the hallway behind you, walk down the hall, bathrooms on the left side, and there's a water fountain there too. I think you can fill water bottles as well. Other logistics, we're going to take a break. You don't have to wait for the break to use the bathroom, but you can use the bathroom during the break. There's food. Hopefully everybody saw the food just outside the entrance here. And there's water at the table in the back of the room. After the exciting presentation, I mean, we're all going to need a nap because it's going to be fun, but we're going to go over to City Tap, which I believe is close walking distance. And hopefully everybody's coming. We're going to watch some games, have some appetizers and food, and have some fun. So I'm looking forward to that especially. And welcome to the new people online. I think that covers most of the administrative stuff. The more important stuff is I want to introduce my co-host today. Two of my favorite people, two of my favorite attorneys. They're excellent. I've worked with you guys for a long time. We've done this sort of presentation stuff before, and it's always fun. To my left, there's Jacqueline Botero and Lee Federer.
Hi, everybody.
Did you guys want to give 30 seconds on who you are, what you do?
I schlepp workers' compensation cases for 3 decades. And I'm happy to keep doing it as long as my body allows, my mind allows it. So hopefully another 10 years, and then we'll see what happens next. But I do know I see a lot of familiar faces, and I see some new faces that I've been emailing with for a couple of years now, and now I have a name to a face, which is awesome. And I look forward to talking with you guys today.
Hi, I'm Jacqueline. As Jason said, I'm going to try to do this without the mic. I hate mics, but if you can't hear me, just let me know and I will switch gears. I also do just exclusively workers' comp. Like Jason said, we try to pretend like we know other things, but truthfully, workers' comp is our mainstay. So so nice to meet all of you, and thank you so much for coming out. And like Jason said, we want to keep it interactive. So feel free to interrupt us. We just want to give you the information that you guys are really looking for.
Yeah, we have breaks in the presentation for questions, but honestly, just ask your questions as they come. I believe there's a chat function so that people online can ask questions in the chat room when I figure out how to look at it. And we'll address those questions as well, because we really want it to be participant guided. Whatever you guys want to talk about is what we want to talk about. We could spend 3 hours just on medical marijuana. We could spend 3 hours on fee reviews. Nobody wants to do that. So tell us what you want to know and we'll tell you. We put together all the questions that everybody gave when they signed up. We tried to address some of those in the slides. Some of them were interesting. Somebody asked what color a mirror was, which I thought was cute. So we got a lot of stuff to talk about, but I think Jacqueline also has some fun basketball March Madness facts.
Fun fact. Yeah, like who isn't likes March Madness? Who's like, I could care less. It's just something on the TV. Who's like forced to watch it because of a significant other? Like, where do we stand in the March Madness? Oh, like, Steve.
What are they showing hands for?
I like.
You like it? All right,
Yeah.
Lee likes it. You're all about it. Okay, so I'm gonna ask it as a question. If you get the question right, you can pick your team.
Oh.
So when was the first NCAA Division I tournament? What was the first year that it occurred?
Question.
Tough. This was the tough one. All right. How about just someone guess
Can we do decade?
all right. Well, I'll tell you all the answers.
No, we can't.
1939, and the winner was Oregon over Ohio State. Thank God they beat Ohio State. Those losers. All right. So, does anyone know when it expanded to 60-14? All right. These are tough. 60s. 1985. And then now this is just a fun fact. Corporate loss due to unproductive workers during March Madness equals 17.3 billion. Sorry, that's me. All right, we'll switch over to that. $17.3 billion loss. So, welcome.
How many gambling winnings? How much gambling winnings though?
I didn't go to the gambling. I thought that might not be positively upon, but anyhow.
Okay, we are excited to talk about death. Who isn't at 9:30 in the morning, 9:45. One thing I always like to ask for these type of things that I forgot, because as Jacqueline can attest, I'm not much of a planned note taker for the presentation style. I like to get a feel for who's in the room. Just show of hands, who's here from like a TPA or an insurance carrier? Anybody? How about an employer, a large employer, a small employer? We got some employer people. We have anybody that works in medical field, like providers, okay? Any claimants attorneys? We had somebody on LinkedIn, Monahan wanted to come. We had a claimants attorney that was interesting. We take all kinds. So that's good. It's good. We'll try to keep that in mind. I think it's kind of the audience we were expecting, but if we address something and you have no idea what we're talking about or why we're talking about it, we didn't put it in proper context, let us know, because everybody's discussion about a topic could be their first time talking about that. And that's perfectly fine, because if you don't know, then there's somebody else in the room that doesn't know. I'm not going to explain to you what death is, but Lee is going to give you, I guess, an example of a fatal claim.
Hi, everybody. About 6 years ago, I got to work on a case that was really juicy and even worse as to the facts than the ones we're going to read to you now. I have changed the names to protect both the innocent and the guilty in this case. And we'll just call this, I'm going to read you a fact pattern, and then we're going to talk about the case, about how we defended the case and the case prosecuted. This case is called the case of Ronald Waverly versus Union Avenue Investment Company. And here are some of the basic facts. Ronald Waverly was 41 years old. He was a client relationship manager for Union Avenue Investment Company. This guy worked hard and he played harder. He managed a $3 billion, that's with a B, $3 billion book of business. And with bonuses, he made $500,000 a year. I'm not making any of this up. He also had a nearly unlimited expense account for entertaining clients. And in the year prior to his death, he spent about $600,000 entertaining clients. So
About what we spent for you all here.
Yeah, those basketballs are more expensive than you might think.
they're stuck with gold. So we'll just call him Ron from now on. Ron had a history with alcoholism and drug abuse, but except for a recent slip up before he passed away, it had been quiet for many years. He traveled a lot. At least half of his job, maybe 75% of his job involved travel, and he entertained clients a lot. His employer put no limits on his expense account, and he was advised by his employer that alcohol would be reimbursed by a standard of what was, this is the employer's words, reasonable and necessary. And it was up to Ron to decide what was reasonable and necessary about booze. So claimant's widow noticed that Ron had been drinking more and more about 3 months before he died. And in December, around Christmas time, because work was slow, he went inpatient rehab for a week. Ron's closest work friend and travel partner was named Johnny Green. And Johnny knew that Ron had been in rehab, but the employer did not know. Only Johnny knew, but no one in the supervisor capacity knew about Ron being in rehab. So about March, about 3 months later, about this time of year.
Why are you looking at me?
This is well after this, 3 months after rehab. Ron and Johnny went to a conference in Miami. Fun place to go to a conference. And Johnny ended up submitting an expense report, which suggested that a good amount of drinking had gone on with a client. So maybe, part of the work environment, drinking with a client. I don't know what's going to happen at lunch today. We'll see. But Johnny later provided sworn testimony before the judge that Ron and he had not been out with a client. He only expensed it because he had exceeded his per diem and he wanted to get the money back from the company. Not making this up. This is the way the case went down. An investigation suggested, however, that the client who was identified on the expense report was at the conference, was at the restaurant, and was drinking at the bar. So we have this lack of clarity about whether or not Ron was with a client or not. Here's the sad part. The next morning, Ron was found dead in his hotel room. There was a white powder next to an open pen next to his bed. And the testing suggested it was fentanyl. So claimant's widow files a fatal claim petition suggesting that claimant's alcohol use was part of his job and the employer accepted it and ignored it, and it was a substantial contributing factor to Ron's death. So we're going to dig in a little bit soon about the elements of a claim, but it seems like it's a pretty educated crowd, but we'll go through the basics and then work our way up. And here's how the evidence came in before the judge. So the widow presents the testimony of a psychiatrist who's a specialist in addiction. And he testified that claimant's job was a substantial contributing factor which led to his death. The employer presented the testimony of a medical toxicologist who said he would have died from the fentanyl alone. The fentanyl had nothing to do with the work. It was something that happened afterwards. But the autopsy report completed by the coroner in Miami suggested it was a combination of alcohol and fentanyl which killed Ron. So employer also presented the testimony of a general psychologist to rebut the addiction psychiatrist. And this guy said it would have been possible for claimant to have navigated a high-stress job while in recovery from substance abuse. So what do we have? We have a beautiful widow with 2 kids under the age of 10. And we have a claim petition for fatal benefits. So I'm just wondering, by a show of hands, who thinks this claim could be compensable? Could, not is, but could. Could be. makes me feel better about the ultimate result of the case, which was we settled the case at a very compromised value, very compromised value. Anyone think there's just no way that this could be a compensable case? D. What's your name again? Cindy, thank you. So yeah, so there's a lot of reasons why it might not be a compensable case and why the value was just beaten down, 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 down. But let's just talk a little bit, and please interrupt me if you have any questions about the fact pattern or anything. Jason, I'm not going to go off the slides yet. I'm going to go into some stuff that's not on the slides.
Okay.
Okay.
He's gone rogue.
We have slides and they're very detailed, but I just want to go through some basics first and then grab onto the slides. What are the elements of a Pennsylvania workers' comp claim? Whether it's a fatal claim or just a regular claim for, oh, my back hurts. I mean, you have to have an injury in the course and scope of employment related to the employment with a subsequent compensable condition. That could be need for medical care, that could be wage loss, or in this case, it could be a fatal claim benefit, right? So what we needed to figure out here, and then one of the questions that someone had given on one of the on the spreadsheet before we got here was, he's a traveling employee. How is he covered during the traveling employee? Does anyone know how a traveling employee is covered? I saw a nod here. Okay, so what was your name again? Patty. Right. So Patty, so you have your company has a policy that if there's a loss of life during work travel, that it's a what did you say? You have a different policy for that? Right. So okay. So Patty's company has a policy. I'm just repeating so that the people online can hear and everyone else can hear. Patty's company has a separate policy that when someone passes away while traveling for work, that the separate policy will cover that event, which is not necessarily a workers' comp injury. Is that the way you put it? So it's actually good. It's probably a decent policy to have, because the benefit you get is that if later on there is a workers' compensation claim, there's an argument that there would be an offset or credit against workers' compensation that otherwise might be due. So that's an interesting policy I wasn't aware of that employers got. Right, so Patty's describing a series of policies that her company might have, which cover incidents involving employees who are traveling for work beyond just a death. David, you had a question? Right. Right. So I mean, David's talking about basically a subrogation situation here, which is a good point too. But because I'll start with Patty, because Patty's so engaged, I think we should give Patty a team.
Yeah, I got Patty, and we have Cindy too, and David.
Patty, Cindy, and David. So let's go with Patty first. Patty, do you have a team? Do you want me to have a one seed? A number one seed, one of the.
Yeah, number one seed.
Okay, so we'll give you Houston, okay? It's fine, your name. What's your last name, Patty?
Oh, that's
Yeah,
good.
you're
You got it.
in the top, so I missed it. Okay. So, Jacqueline, who else do we have besides Patty?
We have David. Here's David. If you,
Okay.
and that's
And then
you.
Cindy, was Cindy engaged? One seed, two seed?
Yeah, that's good.
Well, we're gonna give you Purdue.
Oh, I love
They decided to 7'10" on Purdue.
Yeah. David, who would you like? Yeah, I would not make it.
Cindy.
Yeah.
I think the Pennsylvania team struck out this year, David.
No, look.
How about we do Creighton? Like Creighton?
Solid.
That's a good one.
I think they're the Blue Jays.
We back, or did you lose
Oh.
me?
We skipped over Duquesne, David. I'm sorry, but it's too far from Philly.
Oh, no.
Right. Okay. So just to jump back to the basics of a Pennsylvania workers' comp claim, which applies to the death claim as well. We have to have an injury, course and scope of employment related to an employment with subsequent some type of damages, whether it be wage loss, fatal claim benefits, or need for medical care. Right. So David's asking a question which is a twist on what we're talking about here. We're talking about traveling employees now. Just for a second, I'm going to address this for a few seconds. A claimant who was hired in Pennsylvania or is principally employed in Pennsylvania or has a contract that was made in Pennsylvania. There's a lot of reasons why you can invoke Pennsylvania jurisdiction, regardless of where the accident happens. That's the short answer. There's about 4 or 5 reasons. Right. So in our case, the claimant's widow could have chosen Florida as a venue to pursue a workers' compensation claim. Our experience, and this is really broad in general, suggests that Pennsylvania is a pretty lucrative venue for claimants, and they tend to choose Pennsylvania over, let's say, one of the neighboring states. So that's my experience with that. But I do want to talk about course and scope and what happens when you're on or off the employer's premises, just for a second, as it relates to this death claim. An employee, whether on or off the premises of the employer, can have a compensable claim when they're injured, when they're actually engaged in furthering the employer's business. And that's the crux of this case that I had 6 years ago. Was this guy, Ron, really engaged in furthering his employer's business or not? I mean, were they in the business of drinking? Was drinking part of what he did with clients? Would clients be more likely to come to him if he engaged with them in that fashion? And that was a big question in the case as well. And I know that there's a couple hardcore people here who would say, no way, this is a claim to deny. And that's the position we took for about a year on this, at least, before we beat down the value of the case quite a bit. Oh, yeah. Yeah, the question was the trigger on the denial of the fentanyl? Yeah. Yeah, it was after hours. There's a huge argument in this case that he was so far removed from his employment. I guess I can share with you a little more details about the case. He, after a night of drinking a drink that was actually called a corpse reviver, I can't make this up. Johnny, whose name has been changed, left. Ron was still hanging out. Ron found a lady friend. They went up to, should I be going into this? Is everyone okay with
See,
this?
we're talking
Everyone
about
okay
death,
with this?
lady friends, drugs. We just need some rock and roll.
So this was a lady friend he had just met.
Why is there no slide for this?
So I don't, that's what it was. And your name again? What's your last name? Will you pick a team? Sure. And while Jacqueline does that, I'll just continue a little more details. So he offers his new friend cocaine, and she tastes it or does something with it. I don't know what she did with it. She goes to him, that's not cocaine. And she ends up leaving, and he doesn't make it through the morning. There were also like straight champagne bottles strewn all over the room. It was a disaster. It was a disaster. So
Did these people testify, Lee? Did it make it to that point?
the lady friend did not honor the out-of-state subpoena. We did put on
Wow.
testimony from the detective in Florida who investigated the case. He was a great witness for us, actually. He acted as though he was the detective and the coroner on the whole thing.
You have a question from the lady over there.
Hey, Brittany. The question was, so the question was any evidence of his misbehavior during prior work trips. We did not have evidence of misbehavior during prior work trips, absent the expense reports itself, which suggest a lot of boozing was going on. He had a very difficult history with using everything from methamphetamine to Xanax to whatever he could get his hands on.
Lee, do you think the fact that he was a hard partying fellow and that was obviously known to the employer previously, did that factor into whether they felt it would be compensable or not?
I don't know if it factored into whether or not the claim was compensable or not, but it did factor into why we looked at the case to try to resolve it. Because we were concerned that the judge might take a look at this and say this was a wink, wink, nudge, nudge situation with the employer, just acknowledging it, ignoring it, accepting it, you name it.
Yeah. Question over there from Paulette.
And just one last comment on that before we get to Paulette. The biggest problem with the case from the defense point of view was that Johnny had lied on his expense report, and he testified. It was a two-part testimony. He testified first that they weren't with a client, and then my client produced all the expense reports, which listed the client's name with Johnny and Ron that night. And then we had to have him come back and testify again, and this part made me cringe. So we ended up settling the case for well below value. And if we have time, and I don't know, I might be going over my time, but we'll talk about how we got to a settlement figure on this case. It was a very compromised settlement, and my client was satisfied, I think. Paulette's question is, how come the employer didn't put a limit on his expense account? I did the math on this. It sounds outrageous that this guy was spending $500,000, $600,000 a year on expenses. His book of business was $3 billion a year. It ends up becoming such a tiny percentage, $3 billion. So he was an investment guy. He invested money that belonged to unions and municipalities. And so it sounds outrageous. I mean, I'm flabbergasted, $600,000 a year on expenses. But when you do it as a percentage of what he's managing and what he's bringing into the company, it becomes like nominal. So
I think Shannon has a question.
Shannon, so his expense report said the client was there. He testified that the client was not there, and then later had to admit he testified that the client was there, and then later testified that the client was not there. The claimant did an investigation where they were able to show that this client actually was there. Became a big problem in the case. We reached out to this client of the business. He wouldn't talk to us.
Shannon, did you have a team that's going to win it all?
Always a good choice. We have a Dookie. Okay, very good.
Shannon took Duke for the folks at home. So you needed that pick.
Give me one sec, Dave. I just want to go into this one thing. So the argument to deny the claim is a really good argument, actually. So Dee's onto something here to deny the claim, because there's a case from 1981 called Capital International Airways. And I don't want to bore you with all the details of the case, but on one hand, the law kind of suggests that a traveling employee is covered door to door, right? From the time he leaves or he or she leaves till the time they come back. But the Capital International Airways case suggests that when a decedent dies during an interval when he has no duties, was off premises, and was not furthering his employer's business interests, no workers' comp. And we did lean heavily into this case during the litigation of it, especially in our brief. We ended up filing briefs, and as soon as we filed our brief, their demand just sunk. So there's a big argument that he's so far removed from his employment that there's no way that this could have been a compensable claim. But, you know, when you're litigating these cases and you see the widow crying on the stand and two little kids named after Philadelphia Philly baseball players, actually, they were named after players, you know, there's concern that the judge might give it to them, and then you're slugging it out on appeal. So it was a worry for us. Dave, you had a question? So Dave's talking about a situation where the employer has a strict written policy where you can't be drinking at work. But the flip side is when the employer kind of permits it or acknowledges it or even pays for it, that could be a problem. And that was our essential problem in the case, Dave. I mean, otherwise there's no way we would have settled it. But this actually leads into the next thing I wanted to talk about, which is a defense. Self-inflicted intoxication is a defense under the Workers' Comp Act, whether it's alcohol or drugs, whatever. If you do it to yourself, it's a defense to a workers' compensation case. So,
intoxication has to cause the injury. So it can't just be completely unrelated. Say you are drinking, but something falls from the ceiling. That's not going to be your defense because the intoxication had nothing to do with the injury. You're intoxicated and you drive. I think you have a much better defense.
Right. So the question is, if he was over the legal limit, and in this case he was, per the autopsy, would that mitigate against anything that the employer might have done to permit this in the past? I mean, the answer is probably. I mean, there's not clear case law on it, but what we do know is that, you know, if you're drinking to excess, it's probably goes past the employer's permissiveness. In this case, although the employer, like, for example, did not know that he had been in rehab 3 months before, which was a good fact for us, actually, that they didn't know that he had been in rehab. They did know that he had certainly been expensing a lot of alcohol over the years and kind of was just letting it go to the side. But I think that in that high investment environment, those finance bros, I think that they enjoy themselves. So it might have just been a situation where the employer was, tolerant of it. So that's where we're at on that. But Jason, I think that maybe we should go to the slides, if you
Okay.
don't mind,
Absolutely.
so we can talk about some of the deep things within the Workers' Compensation Act itself about death benefits. Let's go to the next slide. Okay, this is an easy part of the Workers' Compensation Act. If the claim is compensable for a fatality, the employer or carrier has to pay a $7,000 funeral benefit. In this case, the employer actually had paid it before the workers' compensation claim was ever valid, so it was not an issue. You see the next slide, Jason?
Has that been increased? Do either of you remember?
Well, it was increased to $7,000.
Yeah, I remember it coming up.
It
It's
went
still,
from $3,000 to $7,000 a few years ago.
yeah, that was an issue.
Yeah. Who can receive death benefits? So the primary recipient of fatal claim benefits is a widow or a widower. They have primacy over anyone else. If there is a widow or a widower who is a legit person connected to the fatal death person, then they're entitled to benefits first. But children can also get benefits, which can increase the benefit over and above the benefit to a widower or widower. If there's no surviving spouse and there's no children, dependent parents or dependent siblings can also get benefits. It's rare, but there's been cases where an adult child is basically supporting their parents. So those people are also possibly recipients of benefits. So this is the way the Workers' Compensation Act reads, but this is not the way the practice necessarily is. But I want to go to the second paragraph first. The second paragraph in Section 307 of the Workers' Comp Act says no compensation shall be payable to a widower unless he be incapable of self-support. This has been overruled. The Workers' Compensation Act language has not necessarily been amended, but because of equal protection rights for gender, a widower has the same rights as a widow. So he doesn't have to show that he was dependent on his wife for support. The first section deals with the fact that you needed to actually be living with the decedent or actually dependent upon them for a substantial portion of support. So I've had cases over the years where a person who died was not necessarily living with their spouse, like a separation type thing, but the spouse was still being supported by the decedent. So even if they're not living together, you can still receive fatal benefits if you're still married to the person. What do we have, Jason? Oh, this is an interesting one. So before 2005, if you were able to show that you had a common law marriage, in other words, you never received a marriage certificate from a county, before 2005, you could still make the claim that you had a common law marriage and receive benefits. But after 2005, you would have to have a legally recognized marriage. This is a throwback to the era. Common law marriages are basically a throwback to the era when it was hard for people to get to the county courthouse to get a marriage license. Not so hard anymore. So at this point, you need to have a marriage license.
That was reflective of a change in state law with regard to common law marriage. That wasn't a comp issue per se.
Right.
Yeah.
Right. So there's a grandfather clause in the comp law, or at least the way it's been applied, that if you were married before 2005, you can still if you had a common law marriage before 2005, you can still receive fatal benefits.
And as everybody can imagine, this type of issue and dispute can lead to awkward, uncomfortable testimony that the judges, the attorneys, and the people, especially giving the testimony, absolutely hate giving. So it can be interesting cases to litigate.
And the next slide is an example of one of these cases where there was a separation. Husband and wife were separated for 4 months prior to the death. The widow began living with someone else, another family, and the family was providing her some means of support. But the claimant and the decedent still were in contact often, and the person who passed away, also was giving money to the claimant for groceries and things like that. So Jacqueline prepared this slide. I didn't read the case, but I do thank Jacqueline for preparing this slide.
All right, I'll ask then.
So Jason, go ahead, Jacqueline.
who thinks that that meets the requirement for dependency, the $40 a week to spend on cigarettes, groceries, and personal items? It says it's yes. All right, so it's a trick question.
I also think yes, by the way.
It's a trick question because it was remanded and we can't get access to the remanded decision. But what the remanded instruction was to look to see if they were necessities of life. So the court wanted them to clarify exactly what she was spending on cigarettes, what kind of groceries she was spending, and what these personal items were. If they were necessities of life, then it was going to be deemed dependent.
Yeah, it's just a bigger context comment. I find hopefully you're not going to get hit with a lot of fatal claims. It depends obviously on your workforce and your insurance, but hopefully that's not going to be your everyday practice. They are, for obvious reasons, some of the toughest cases to litigate. And it's not necessarily just because you're litigating over the death and whether it's compensable. For me, I think one of the more uncomfortable things are these type of things. You're not a dependent little 5-year-old. You get nothing. You only get $20 a week. You only get it until, oh, hey, are you in college now? Or we don't know. We're going to fight about that too. So it's uncomfortable for everybody involved. I put it on the line with, I also don't like scar claims because you're essentially arguing why somebody's so ugly that their scar on their face is not compensable because you've got all kinds of scars on your ugly face and we'll give you a week. So they're tough claims to get your arms around and yeah, that's my input. Next slide.
Yeah, please. So we've already discussed a little bit about how the widow or surviving spouse is the first in line to receive benefits, and they receive a certain amount of benefits. I think it's 51% of the average weekly wage. But if there is no widow or widower, the next in line is children or dependents. And this can be a pretty broad category of people who are considered to be children or dependents. Children only receive the benefit directly if there is no surviving spouse. However, in a case that we discussed earlier regarding Ronald Waverly, the wife was entitled to a certain amount of benefits, and because she had 2 kids, that benefit rate went up. We'll get to that in a little bit. I got here, Jason. So benefits to the children's benefit is payable until age 18, but can be bumped till age 23 if the person is enrolled as a full-time secondary school student. Okay, so I'm actually dealing with this right now where I have a case where the child is receiving the benefit because there was a divorce. So all the benefit is going to the child, and she keeps going in and out of college. So we keep kind of stop paying her, and then she enrolls in a new program and we pay her, and then she's off for 3 months. So, and it's not just a summer break or anything, so she's quit and then she goes back. So we keep stop paying her and then paying her again. And hopefully she'll be 23 soon and we can stop paying her entirely.
And the age requirements, though, 18 and 23, they do not apply if it's a child that has a disability that made them dependent upon the decedent.
Yeah, that's a good point. Thank you so much. So children include all natural and posthumous children, legitimate, illegitimate, whatever. It can also include people who are living in the house, young people who are living in decedent's house, if the decedent was acting as their parent. So think of a niece or a nephew who's now taken up living with the decedent's family. That person could be considered a child of the decedent as well. What else you got, Jason?
A little more on a loco parentis.
Yeah, I think we can all take a look at this one ourselves, but
It's a Latin phrase.
1 year of high school Latin
Yeah.
could be well. Here's more on in loco parentis, but it's just talking about whether or not the child who's not the natural child of the decedent would be entitled to receive some type of benefit or an increased benefit. Okay, so if there's just a surviving spouse, that surviving spouse I think receives, I think it's 51% of the average weekly wage. If there's one child, that bumps up to 60. If there's 2 or more children, that bumps up to what we often associate with workers' comp, which is 66 and 2/3. So that's how you structure the payout. And it's actually kind of important. Like in the case that I was describing at the beginning, Ronald Waverly, we did a lot of math. We figured out how much the widow would receive based on her life expectancy, which was another 42 years. We then added in child 1 up to age 20, up to age 18. Then we did child 1 up to age 23, and we did the same calculation for child number 2 as well. And that's why we had somewhat of a range of how much we thought the case might be worth. The next situation doesn't happen often, but it can happen if there's not a surviving spouse. Parents who can show dependency on the decedent can receive a benefit for workers' compensation. And the same thing goes for siblings. But siblings don't have a right if there's parents who are dependent first. Is that fair, Jacqueline? Did I get that right?
That's
Okay.
Swisher?
You know this case, Jacqueline Swisher?
So this was a case where the parents filed for benefit saying that they were dependent. There was a family farm. The parents worked on the farm, so did the son. The son was the one who passed away. And the parents then claimed a benefit. And what was interesting about this is that the farm itself wasn't overly expensive to run, and the parents' finances, in my opinion, would have seemed pretty stable. But since there was really a financial contribution from the son, the court did find that there was a certain level of dependency. I probably am going to jump ahead to Lee's next slide. Parents don't necessarily have to have the 51%. There is a range that the court can find anywhere from 35% up to 50. I think it's actually 52. So the court could say, okay, well, you were dependent upon the decedent for $200 out of that average weekly wage, and they have a little bit more discretion to pick a number that makes the parents whole had the individual not passed away.
And just so we know, when we're talking about the benefit, it can't exceed the statewide average weekly wage. So it can't go past the max comp rate. So in Ron Waverly's case, he was making $500,000 a year. So he was making $10,000 a week, but they were still capped at the maximum comp rate for that year. So yeah, a surviving spouse can receive benefits for the rest of their life. And that was a big factor in why we settled the case, because the widow was 42. And she had a life expect. Now that she had already gotten to 42, her life expectancy as a woman was another 41 years, I think, at this point in time. So it was a big factor in why we settled the claim, because the exposure was so high. If the widow remarries or the widower remarries, they get a 104-week lump sum payout. What I've seen is I never see the surviving spouse get remarried, because I think there's a financial incentive not to get remarried. So I haven't seen it at all. There is this portion of the act talking about a meretricious relationship where the surviving spouse is involved romantically in a very serious way with someone else. Good luck proving it. I don't, you can send your investigator out, but once the door or the window shades go down, good luck proving this. D, you had something? So Denise is describing a case where she was actually able to prove, Denise is a senior claims representative, and she was able to actually prove through investigation that there was a meretricious relationship. Kudos to you, Denise, because I've never been able to do that, but I give you a lot of credit. And did you pick a team yet? No. No, sorry.
Not this year.
Someone else? You want a suggestion?
Suggestion? All right. We got so number 2's left. We got Marquis, Tennessee, Iowa State. I'll do Tennessee. Tennessee, all right.
Denise has a question, yes. The question is, if someone has a work-related injury and dies from it later, is there a time frame during which the dependents can then file a fatal claim petition? What do you think?
3 years from the date of death.
That's my first thought was 3 years from the date of death as well.
So that brings up such a fascinating and important point. They're separate benefits. So even though someone is receiving workers' compensation benefits and maybe receiving them up until the date of the death, that does not automatically mean that there's going to be a dependency award of a fatal claim. So they are two completely different benefits. So you have a chance, even though you accepted a claim, to potentially dispute that it was caused the death and/or if there's dependency issues.
And I believe there's also a different standard for occupational disease. I don't know how many weeks it is, but I believe there's a bigger window if you have an adjudicated or accepted occupational disease that you eventually die from. So
I'm just going to wrap up talking about how we value the case for settlement, and then I have a question for the group.
Can you talk about hugs and kisses?
Hugs and kisses? There is a slide dealing with hugs and kisses for the people who are online who might not have the PowerPoint, but I guess they probably do.
They certainly do. Yeah.
Okay, all right. Yeah, Jason, my hugging and kissing Jason doesn't establish our precious relationship. I'm sorry. How we valued the case for settlement. We did all the math. We averaged the highest and lowest exposures based on the widow's life expectancy and the children, both to 18 and 23. We then put a present value on it. We then cut it in half immediately, because we figured we would win this case. If pushed, we would win the case. So we immediately cut it in half. And interestingly, claimant's demand was pretty darn close to our half figure. So I guess claimant's counsel did the same math. I don't know. I'm going to quiz her sometime on how she got to her demand. And then we went to mediation, and the mediation, I didn't like the way the mediation went down. The demand didn't really come down nearly enough. The demand came down by about a third. And then after we filed our brief, and I think when they really saw how we analogized our case to this case I was talking about before, which was called Capital Airways, which is our case, I think was worse than the fact pattern for the decedent in Capital Airways. We ended up settling it for about less than a third of how we had valued it. I thought it was worth settling. You never know what a judge is going to do with a case. If the judge granted benefits, we're slugging it out on appeal on some credibility issues, maybe. Maybe the judge didn't like our medical toxicologist conclusion that fentanyl alone would have killed the claimant. There were a lot of reasons not to settle the case, and there were reasons to settle it as well. So I thought we got decent value on the settlement. It was less than a third of how we had valued it, the 50-50 proposition. I got nothing else on this topic, Jason.
Yeah, I think just to comment on the settlement, I think as uncomfortable as they are, fatal claims, once they've been accepted or adjudicated, are probably better to settle than a traditional comp claim. You take the example of the young lady who was, now a widow and she's out dating. People want to move on with their life. So, it's a math problem. Lee's doing his math on the carrier side, the plaintiff's attorney's doing their math, and they're going to come up with the biggest number possible. But a lot of times the person, from the soft side of it, they want to move on. They don't want to feel like they're doing something wrong by dating after their husband or wife died 5 years ago, but they also feel like, hey, I'm entitled to something that this person passed away because of their job. So I think if you have the right approach to it, that's probably a good case to mediate if you get a good mediator. And, you can sit down and do the math, but you can also have a more motivated person settling than perhaps somebody who has a spine cord stimulator that's never being taken out of their back, and they're not going to move on from their back injury.
Right, and in this case, maybe we were able to get a good settlement because the widow really was looking to move on with her life. She had also received some money from the employer in terms of life insurance policies and things like that. Unfortunately, Ron was too busy partying to buy his own private life insurance, which is a shame. I just want to wrap up. I have one question for the crowd. I do have a very good client here who is very tolerant of all of my mistakes. And I recently thanked him for being tolerant. And the client sent me back a 1980s movie quote that I can't pin down. I did not Google it, but I'm hoping someone in the crowd can tell me the name of the movie this quote is from, and then we'll give you a sticker. The quote is as follows: "Don't think twice. It's understanding that makes it possible for people like us to tolerate a person like yourself." Anyone know what movie this is from? Anyone? Matt, what's that? Okay, we'll take a couple hints. John Hughes movie, and I guessed every John Hughes movie I could think of. I guessed Planes, Trains, and Automobiles, and I was wrong. Anyone? Jason, Jacqueline, you're younger than me. Matthew Broderick movie. Okay, so Carmela, you already have a sticker, but Matt, you have a team? All right.
It was Ferris Bueller was the answer
Yep.
for the people at home.
Yep.
We had a Ferris Bueller quote. And it wasn't from the Sausage King of Chicago? That wasn't him. No. All right. Should we fire up the weed?
Sure, let's do it.
Okay, so not related to death claims, medical marijuana 2016 came about, I think it's become more and more common. You guys are probably seeing claimants using medical marijuana, either submitting to you for payment or you find out about it other words. So I think we're going to circle back on where it came from, where the act came from, and then where it's at today. Jacqueline?
Perfect. Two disclaimers for this. One is that we've done a presentation on medical marijuana many times, and that presentation is hours long. So we are giving you like the ultimate little shortcut Cliff Notes version here. If you guys want more information, want the whole presentation, let us know. We're happy to provide you with more information. We're happy to provide you with another presentation. Just, let us know what you're looking for. The second disclaimer is that when we do these medical marijuana conversations, they always lend to questions related to employment law. For example, what kind of accommodations do I need to give? I am not an expert on employment law. We have experts in the firm. So if you have questions about employment law, just reach out to us and we'll get them to the right person so that you get a more accurate answer. I've heard their answers a bazillion times, but I'm not the expert. So I don't want to pretend like I know what I'm talking about in that arena. But like Jason said, in Pennsylvania, we have medical marijuana. The important framework to remember is that on a federal level, marijuana in all forms is illegal. And that's important to have in the back of your mind. The federal government a number of years ago issued a memorandum. And that memorandum basically said, we are not going to prosecute states that implement laws about recreational use of marijuana, or like in Pennsylvania, medical marijuana. That is not law. That's just basically their statement on where they stand. That could change at any time. I don't have any reason to believe that it's going to change or that they're going to withdraw that. But just know for our conversation today, it's where things stand today in this moment. Could evolve. It could change in the future. Why that's important. When we look at federal versus state law applies in the four corners of the state. Once you start involving crossing borders, you fall into federal law. So when these states implement medical marijuana or recreational use laws, everything needs to be confined to the state for it to fall under state law. So in Pennsylvania, it was in 2016 that PA Senate Bill 3 was passed that implemented the medical marijuana laws and requirements. But because everything had to be done in state, it took about 2 years for the first medical marijuana dispensary to be open. So it was open in January of 2018, partly because they then needed to contract the growers and the packages and set up the dispensaries and really start from ground zero to build it up in the state. So in Pennsylvania, we have, I'm going to go to the next slide.
Yeah, just to jump in and be rude and interrupt. We had a presentation on medical marijuana in this room. I think somebody said they were here. We got some heads nodding.
It was on 420.
Yeah, it was in April. We had lava lamps. We had all kinds of shtick. And it was like 7 years ago. And that's how fast this has moved. We had the opportunity, I know Lee and Jacqueline were involved as well. We met with some of the legislators, actually the two legislators who were pushing the bill. And we were giving them feedback on some of the language in the bill as it relates to Pennsylvania workers' compensation claims. That'll come up later in this presentation, but it's amazing how fast the industry has moved. And just as she said, 2018 was when the dispensaries were open. We got to tour a dispensary, which was really interesting. And now it's very commonplace. So on to access.
So I'm going to go over who has access and how they go about it in the state. It is for individuals who have, quote, serious medical conditions. That is the language of the bill. That's not my language. We'll go over what those conditions are in a few minutes. And so the process is that an individual who thinks that they may be eligible, who thinks that they may have one of these serious conditions, they first register with the state on a website. On that website is a list of all the physicians that are approved to perform a medical marijuana evaluation. These physicians basically went to a weekend course and then they were certified by the state. There are a bazillion physicians on this list of all different practice groups in all different counties. So it's very accessible. So the second step is after they register with the state, they then undergo an evaluation with one of these physicians. That evaluation is not something that can be billed to insurance. It is something that the individual pays out of pocket. The evaluations are between $150 to $200, but I have to be honest, I've seen like Groupons for them now at this point. So I think that they're becoming even cheaper. I think that doctors are doing it as a draw of quick cash. So they go to this evaluation with the doctors. The doctor then certifies that this individual has a serious medical condition as set forth by the state. They will give them the appropriate paperwork. The individual will then file an application with the state for medical marijuana. The state will approve it, assuming that everything is in line. They pay a $50 fee and they get a medical marijuana card that lasts for 1 year. In Pennsylvania, you also can get approval for caregivers to be certified. So if an individual can't go out of the home, has limitations, the state does allow an individual to list 2 caregivers to give them permission to access medical marijuana on their behalf. But if you want to go forward to the next slide, this is the list of all the serious medical conditions that allow for eligibility for medical marijuana in the state. There are a couple conditions that jump out to me as conditions we might see in the workers' comp arena. I picked the ones that I think would be the most common, but I think there's probably arguments for other ones on there. And they would be neuropathies, post-traumatic stress disorder, severe chronic irretractable pain, anxiety disorder, and then the opioid use disorder. So I think that it's important to look at this list and know that medical marijuana definitely has an overlap with conditions that we are seeing in the comp arena.
Yeah, and when Senate Bill 3 was being debated, I think they started with 14 enumerated conditions. When the bill passed, I think it was 16. Obviously, it's now expanded to 23. That was known that it was going to expand, but there were fights over, is this something that's going to be covered for medical marijuana? Is it not? So it's a very developing area of both medical treatment and the legislation.
So now, what does that mean for all of us in this room and the workers' comp arena? There isn't a tremendous amount of guidance right now, but there is some. Again, the case law is a snapshot of where things stand today. The outcome could be different in 6 months from now. So just know that the first case that was decided was the Fagley versus Firestone tire. The claimant in this case had an injury in 1977, had 2 failed surgeries, was taking opioids for years on end. In 2019, they took it upon themselves to look into medical marijuana. They were appropriately certified, but through the process in the state, began using it, and through the use of medical marijuana, they were starting to wean off all of their opioids. So there definitely was a benefit to them. In 2019, a utilization review determination found that the medical marijuana that this individual was taking was reasonable and necessary for their condition. Despite that, the employer or the carrier was not paying for it. So in October of 2019, a penalty petition was filed to seek penalties based upon the failure to reimburse for the out-of-pocket cost. At the WCJ level, the WCJ denied the petition, basically finding that there's no obligation to provide this benefit. The appeal board affirmed. It went to the Commonwealth Court. In front of the Commonwealth Court, if you want to go to the next slide, the Commonwealth Court is very long and technical, but the most important consideration or distinction that they did was that they looked at the Medical Marijuana Act and looked at the language of it. And the language says nothing in this act shall be construed to require an insurer or health plan to provide coverage for medical marijuana. So what the Commonwealth Court did was they distinguished between providing coverage and reimbursing. So they basically said, we're not telling you you need to provide coverage. We're just telling you you need to reimburse. And
can I just jump in for a second?
Yeah.
I don't know if Lee remembers, but when we were going through this process, and they were sending us the language, we specifically pulled out this sentence from Senate Bill 3, and we sent it around to a couple Chartwell lawyers, and we were concerned about it. You remember this?
Yeah, I do remember.
Do you remember why we were concerned?
No, tell me.
We were concerned, and this is our genius lawyer forethought. We weren't concerned because it doesn't say anything about reimbursement, because frankly, I think that's stupid. I think the Commonwealth Court got it wrong. We were concerned because it doesn't specifically delineate employers. So it talks about insurers and healthcare plans. It doesn't say anything about self-insured employers. It doesn't say anything about self-funded healthcare plans. We brought that up repeatedly to the legislators. And of course, when they're looking at a bill like that, they have 10,000 suggestions from 10,000 different industries. They didn't listen to us. This is the language that came in. So I apologize that we didn't have the forethought to identify the reimbursement issue. I still think the Commonwealth Court got it wrong, but Jacqueline can explain their reasoning.
Well, Jason just teed that up perfectly. So basically, the Commonwealth Court said they could have put in the act that they were prohibiting reimbursement, but they didn't. And simply because they did not include that language, we're going to say that reimbursement is possible and allowed. So Jason, thank you for teeing that up perfectly. So basically just the omission of the language was the basis for them finding that it was a requirement, or it could be a requirement, we'll call it that.
Yeah, I would note that the act does allow for reimbursement of out-of-pocket expenses incurred by a claimant. So I guess this is what they were leaning on, although, well, boy, oh boy, it's a tough distinction between what's coverage and what's reimbursement.
Right.
Right, that's a narrow.
I didn't read the briefs. I think the argument would be you can't circumvent by a reimbursement what could potentially be illegal by a federal law. It's a straw purchase.
That's a
You're
different case.
Yeah.
Well done, Jason. It's like we practice this. Well, there was another case that just addressed exactly what Jason said. When we had been talking about this and some presentations we did in the past, all of our arguments were, well, you can't make me violate federal law as an employer. That seems pretty ridiculous, especially I know that there are employers out there that receive federal funding. And so there was a big concern about, well, how's that going to impact my federal funding if I'm not complying with federal law? So there was a second case that was decided more recently, and that's called Appel versus GWC warranty. And that's the exact argument that was raised by the employer. The employer said, you can't force us to do something illegal. You can't force us to pay for a drug that's illegal on a federal level. The court, again, was very much, in my opinion, parsing words and being, I think, a little more specific than should be done. But the court said that they are not having the employer prescribe or provide the substance. They're just having the employer reimburse someone for their lawful use. And so it's not a violation of federal law to reimburse for lawful use. That's how they phrased it. Where things stand, these are Commonwealth Court decisions. So the Supreme Court of Pennsylvania has not yet addressed it. I do anticipate that that will occur at some point. The Fagley case that I started with, that was actually remanded to the judge to assess an actual penalty or determine if an actual penalty amount should be awarded. So that could still be appealed up. And I believe that Appel was also appealed. That's a more recent case. So stay tuned on that. And then the third case that somewhat related, I just find fascinating because it involves a claimant's attorney that we know. It's called Schmidt versus Schmidt Karafides. Mark Schmidt's a claimant's attorney in the Delaware County area. So I don't know if any of you have seen his name on your cases or claims, but he, as the injured worker, filed a penalty petition because he wanted his employer to reimburse him for CBD oil. So the court did distinguish that that's not marijuana, that's not medical marijuana, it's completely different. They actually phrased it as a dietary supplement and said it certainly could be reimbursable, but they were saying basically we can't address reasonable and necessity. That has to be done through a UR process. So employer, if you have issue with this, go file a UR. But CBD, you are different. You are not medical marijuana. You do not fall in the same realm. So that's where we stand now. But like I said, I think that this is very much evolving. So right now, as things stand, if medical marijuana is deemed reasonable and necessary, there is a strong argument that it should be reimbursed. I think that these cases are still narrow because they all find when it's reasonable and necessary. So that to me, I think you have to have first. But again, it's hard to challenge that if the injury that is acknowledged is one of those serious medical conditions that's on the screen. Things that I would recommend is making sure that you are in fact paying for reimbursement for a serious medical condition that is related to the work injury, not something else. So I would ask for all the information about the actual evaluation that occurred, what conditions they were approved for, when, and I would also ask essentially like, what are they, what's their plan? And I know that's a very vague question, but I say that because one of the things that's most interesting about all of this is that a doctor does not prescribe medical marijuana. They just simply approve a person for it. So there is no prescription of take this amount, this dose on, in this frequency. It's really up to the injured worker to make those decisions on their own. And so when Jason and I went to a dispensary, one of the things that we learned was that the techs behind the counter who are selling the product are really a valuable resource for people coming in there to purchase the product, because they'll have conversations with them about what are your goals with this product? What do you want to achieve? So they can make the recommendations for strands and dosage. But that's not something that as an employer or insurance carrier, you have any control over, which I think to me that's the tough part. But on the other side of things, it could be a much cheaper and safer option than opioid medication. So it is something to consider.
I have a couple of questions.
Oh boy.
First, anyone out there who's seeing medical marijuana prescribed within their practice, do you think that it represents a savings over other drug use, or you haven't gotten that far yet? Anyone? Haven't gotten that far yet to analyze it? Has anyone analyzed it? Right, so it's the comment is that there's a likelihood that there's a savings versus opioid costs. But there's also a lot of questions because who knows how much marijuana the person should actually be using.
And so, yeah, that's something that when we went to a dispensary, Jason and I asked them a number of questions about this. Every time a person makes a purchase at a dispensary, it has to be registered with the state. So the state does control or make sure that they do not exceed a certain limit. So we asked them, what is this limit? Like kind of put it in layman's terms. And they were like, it's a pretty hefty limit. Like it's a lot. Someone's not going to run out. But it's in their mind a limit that if someone were doing something illegal with it, selling it, whatever, they would be able to catch it. But I found that fascinating because I remember them describing it to us of like, it's a lot that someone can purchase at a 30-day supply. But, I don't know where that equates to cost-wise. I would imagine that if someone's buying the full 30-day supply, it could be more expensive than your ability to reprice a bill, or perhaps, utilizing various measures to keep costs low.
I also have one more thought about this. On the Fegley case, they were talking about actually reimbursing the claimant for the marijuana itself. But what happens when claimant submits a receipt for the evaluation to the doctor for $100 or $150, or submits a receipt for the medical marijuana card that the Commonwealth requires for $50? I would assume that would also be reimbursable. Although the case didn't talk about it, why not?
Yeah, I think that there's a strong argument for that.
Yeah, and my last thing about medical marijuana is it's interesting that some of these cases come up within the utilization review process, because the science on the efficacy of marijuana is so lacking that it's a wonder that a reviewer could determine that it was reasonable and necessary in the first place. But I guess they're doing it.
Yeah, I'm not a medical marijuana advocate. I frankly don't have a problem with it, even though I always argue it's terrible and you shouldn't pay for it. The problem with the scientific research is it's a Schedule I drug. Yeah. So Jacqueline opened with federal versus state. The elephant in the room, in the nice sunny corner of the room, is the federal issue. If it's moved off of Schedule I federally, which has been brought up repeatedly, all of this stuff, Fegley, the state organization, there's a sunshine provision in the Medical Marijuana Act. So if it moves off Schedule I and there's, federal standards with regards to use of medical marijuana, medically, then the entire cottage industry that has popped up all throughout the state and through other states is really going to be thrown for a loop. Is that good? It might not be, because then you're going to go from, reimbursing the claimant for paying out of pocket to buy, and Jacqueline remembers the different names of the strains.
Indica and
Yeah, the purple mishmash and hish hash and all the good stuff. You go from reimbursing an injured worker for that to now you're paying a mail-in pharmacy. Now you're paying CVS, and now they're combining it with codeine. Now they're combining it. They're putting it into a topical pain cream. And that's where I think that's where your costs come in. So it's probably a good thing if we have a uniform federal standard. I think that will increasingly drive up costs.
One last just thought that, there's a little bit of slow movement afoot in Pennsylvania to make recreational marijuana. So if recreational becomes legal and the claimant no longer has a prescription for it, or no longer has to be medically evaluated for it, should we reimburse his recreational use? I would think not.
I agree. Sure. So just for the people at home, what was said was that while the cost may be lower from a pharmaceutical perspective, when it comes to return to work, the costs increase because the use of medical marijuana could violate the laws or the requirements of the employer when it comes to modified duty. So it therefore makes it more difficult to accommodate restrictions and whatnot, which is a very valid and wonderful point. Thank you for bringing that up. I think we have David. Go ahead. Yeah, absolutely. So, do you want to add to that before? Well, we've also right. That's the problem. If you ever have the opportunity to visit one, I highly recommend it. It was a really cool experience. That sounds really. Was it the day that they opened that we went, or the day after?
It was in the beginning, yeah.
Yeah, and so what was interesting is, again, it does not remedy the issue of a doctor actually prescribing something. That's definitely an issue. That is something that I think we need some guidance on. But what I thought was really fascinating is that the dispensaries have a pharmacist. And so once you log in, you show up to the dispensary. There's a separate room away from the product that you have to sign in, show your card. They make sure you're a valid recipient through the system. And then the next step, if you want, but it's optional, is you could speak to an actual pharmacist about your condition, and they can give you recommendations. What we learned was that pharmacist is there, but the people really get the information more so from the techs. The techs are the people that work behind the counter. And when we were there, and I don't know if this was just a fluke of the location we went to or the day that we went, most of the techs said that they were all medical marijuana users themselves, and they were in other states before it became legal in Pennsylvania. So it's not a doctor giving this information. It's other users and it's other individuals that, I think we were there, the average age of the person had to be like 25. Like, it was a very young population, really, with the education based from their own use. Absolutely.
Yeah.
What is your name, sir?
We know you, David.
Right next to you, David. Steve, yeah. Okay, Steve, do you want to pick a team?
Are you familiar with our bracket, Steve, from March Madness? One of the teams left.
So Steve, because you participated, you can pick a team, and if your team goes the furthest, you get
Take a break.
prize. So we got some good teams left. If you have like a lucky number, Baylor's number 3 still available. We got Marquette number 2.
Marquette.
Marquette, yeah, Marquette. There we go.
I don't think they'll.
Ballard, okay.
All right. While Baylor's being offered up for the win, my wrap-up comments, there was a couple questions about prescribing. Why aren't doctors prescribing? There's 2 reasons for that. As Lee touched on, there's not a lot of medical literature backing up what you should prescribe when it comes to medical marijuana. So there's just not a lot of medical science information out there that the doctors are trained to know how to prescribe it. That's one issue, less of an issue. The bigger issue, the reason that Pennsylvania doctors are not prescribing medical marijuana is not a function of the Pennsylvania Medical Marijuana Act. It's because they're all licensed and they're AMA and they're board certified, and that's a federal standard. So they can't prescribe pursuant to AMA standards. They can't prescribe a Schedule I drug like that. So that's why even when they started the act, everybody knew that the doctors weren't going to be able to prescribe. So what happens is you do go to the dispensary. It's kind of like when you go to the paint store and they say, hey, maybe you want the eggshell. Maybe you want a matte. Maybe this person's a lifetime painter. Maybe they're 16 and it's their first job. You really don't know who you're going to get telling you what to use. Shannon.
You have to be a resident of Pennsylvania to be certified for Pennsylvania medical marijuana. So you have to have a driver's license or a photo ID from certified and issued by Pennsylvania. So you couldn't live in New Jersey and get medical marijuana in Pennsylvania. And technically, if you cross the lines, I don't know that anyone's really going to pull you over and say, you have marijuana, you have a medical marijuana card from Pennsylvania and you're in New Jersey. I don't know that they're going to do anything, but technically that's not supposed to be allowed. But who's going to really do or say anything?
Yeah. All right. So why don't we take can we do a 7-minute break and we come back at 11:10? We ran a little long, so we're going to try to get everything in we can. Okay.
Sounds good. 7 minutes.
What topic are we going back?
Fee reviews, baby. Yeah. All right. I'm going to get started as people are filtering back in because we're going to talk about fee reviews now. And I just can't wait anymore. I know you guys are excited. I'm excited. I was just commenting before we resumed about the stock PowerPoint photo, and the gentleman seated at the left side to the foreground. I didn't notice it when we first made the slideshow, but he looks like he does not like flying. And am I right? He's like the most miserable guy on the flight. And I don't want that to be you when we talk about fee reviews. So that's my inspiration. You're not going to be that guy. You might be somebody up somewhere else on the plane. You're on your phone. You're not shutting it off when you're supposed to, but you're not going to be him. So, all right, let's go. Let's talk some Pennsylvania fee reviews. What we're going to talk about is how does the process work? What is the Pennsylvania fee review process? We're going to talk about hot topics. However you refer to them as hot topics, that's a very generous term when it comes to fee reviews. And then we'll talk about the recent Federated decision, which changed a lot with regard to how all prescription medication is paid for in Pennsylvania. As with earlier portions of the presentation, and especially now, if you have any questions as we go, any comments, any insults or jokes, please interrupt. I don't know if everybody's gotten their sticker on the board yet, but we'll make sure we do that before we wrap up. How does the fee review process work? Well, more so, and I'm not going to follow the slides word for word. I know you all can read. What is the fee review process? The fee review process is the only place in Pennsylvania workers' compensation claims where parties can fight over how much it costs and how much should be paid for a medical treatment, for a pharmaceutical, for a piece of durable medical equipment. That's where we do this. So if you get a bill for an opioid, you think it's overcharged, you reprice to a certain number, and the provider thinks you didn't pay them enough, they will put you in fee review. And that's an important thing to remember. It's a provider-initiated process. So you as the carrier, the adjuster, the TPA, and the employer, you're never going to file for fee review. That's not how it works. The provider files for fee review. Your remedy, if you think you've been billed too much, is to pay less. So if you send me a bill for a certain prescription and I think it's not a $500 prescription, my repricing people say it's a $50 prescription, you pay the $50. If the provider's okay with that, they say thanks for the money and they go about their day. If they're not okay with it, they file for fee review. So as the act sets forth, you have 30 days, and I think most people are familiar with that. Once you get bills and arguably records, supporting those bills, you have 30 days to respond unless you're fighting over the reasonableness and necessity of the treatment. And the regs, the medical cost containment regulations, are really where we look to for the fee review structure. So one of the things that we fight about a lot in fee reviews is the issue, which seems kind of basic, of a provider. I told you that only provider can file for fee review. So why does it matter if they're a provider? Because sometimes we have people submitting bills to you folks that aren't necessarily a medical provider. They might be a billing agent. They might be somebody who sounds like they're a pharmacy, but they're not really a pharmacy. And that's a very big issue when it comes to repricing of bills, because if they don't have standing, if they're not one of these enumerated lists of groups, then they shouldn't be seeking remedy before the fee review officer. I'm not going to go through all of these, but we're going to talk about reimbursement in general. So what are some of the things we fight about? We fight about in fee review, usual and customary charges. If it's not something that's delineated, if there's not a repricing standard for it, some of you might be familiar with the fact that we go to a usual and customary standard. That's what's it charged at in that region for that treatment. It can be very hard to find that out because a lot of the providers don't want to give up that information. They don't want to let you know that the ambulatory surgery center bill that they're sending to you for a workers' comp claim, they get 20% of that amount if they're paying through it for healthcare. So we have a lot of disputes about usual and customary. Durable medical equipment can become an issue, whether it's a neck brace, a home therapy device, a TENS units, things like that. Ambulatory surgery centers I just mentioned, and then we'll see a lot of trauma cases. So if you treat at the emergency room, you treat at the hospital, and it comes in as a trauma case, most people are familiar with the fact that it's paid at a much higher rate. We got pictures. So how are bills submitted? I'm not going to show you the form, but I think everybody's familiar with the HCFA forms. If you didn't get the HCFA form, you probably shouldn't be paying for the treatment. And medical reports is a little bit sketchy. I don't think every adjuster out there gets a medical report supporting every bill. Maybe you guys do, which is great. But I think for some of your claims that are old hat, a claim that you've had for 2 or 3 years, you might get a HCFA form every month, and then every couple of months you'll get the updated treating records. Could you deny that bill because you didn't get a treating record that month? Theoretically, but to be honest with you, it's probably not worth the cost of fighting over that issue. We talked about 30 days after receipt of the bill and the report, you have to respond. There's some mailing issues, probably less of an issue in the modern age, but these regs were written before COVID. So you have 3-day mailing. They'll give you the credit for the 3 days of mailing. And we also talked about the HCFA is the form that you receive. The EOB is the form that you have to get back. So your explanation of benefits, you're going to set forth your reason if you repriced. If you denied, you're going to set forth your reason. I know it can be difficult. A lot of carriers, a lot of TPAs only have certain reason codes for denial. And sometimes the attorneys will tell you to be more specific and say this. And it can be hard to change what the drop-down menu tells you can reprice as. The deadline can be extended. It can be extended. We have an online question, and I'm going to read it to myself before I read it aloud because I'll inevitably stumble over the words.
All right, while you read that, I'll give another fun fact. Odds of a perfect bracket, 1 in 9 quintillion.
Oh.
Someone out there's got to do it. Someone's got to be the one.
How many zeros is that?
I don't know. I just wrote the word. And then also beer sales increased by 26% during March Madness. We'll help that percentage in a few minutes.
Okay, so I read the question. I'm not going to tell you what it said yet because it's going to come up on the next slide. Where were we at? Okay, 30 days for payment. It's going to be told if you request utilization review. Jacqueline and Lee mentioned utilization review during their discussion of medical marijuana. If you're not familiar and you want to be bored by something else, utilization review is where we fight over the issue of reasonableness and necessity. So I don't think that your medical marijuana is reasonable or necessary. I'm going to request a utilization review. I think your medical marijuana is great and you should be taking it, but I don't want to pay what you're charging me. That's going to be something you fight over in fee review. So if you do submit that utilization review request, it will toll your response times for the bills. Down coding. I don't know if anybody does this frequently, but if you're going to down code, that's a situation where a bill comes in, it's billed as something. It might be billed as some sort of generic coding entry, but you can tell both from the bill and the treatment records that it should have been billed in a different manner. You can respond with your down coding proposal. You can send your payment, but that's not going to extend your time to respond. You still have to pay something. And I think that's something to keep in mind for any fee review issue. On the employer side, on the carrier side, you have to do something. You can't just sit on it. Application process. So it starts, as we said, with the provider submitting the application for fee review. They have to do that either within 30 days of the disputed treatment. That means once you send your denial, they have 30 days to file for fee review application, or within 90 days of the original billing date, whichever is later. So they get that generosity of the act that they get 90 days if you didn't send a denial. The question that Eric brought up was actually on that issue. The adjuster said that she received a fee review application for a bill that she had never seen. And we do see this a lot. And she responded back to the fee review folks and said, I never saw this bill before. I don't know why they're submitting for fee review. I didn't downcode it. I didn't deny it because I've never been provided this bill before. They're going to refer you, the fee review people will say that you have to challenge the fee review determination. Generally, you will. So you'll have to file a fee review hearing request, which we're going to get to in a minute. A practical solution is if you haven't received the bill, you have the fee review determination, take a look at the bill now. If it's something that's compensable that you're going to have to pay anyways, then it's probably not worth fighting over, and it's probably not worth paying me or another attorney to go before a fee review officer. See, these online people, they love the fee review stuff. I'll tell you what. All right. Everybody having fun? Yeah, good. No question? No? Okay. We talked about the application itself, 30 days, 90 days. It's submitted only by the provider. We all know that now. What happens? So it goes initially to the administrative review process. That's the good folks in Harrisburg, theoretically in Harrisburg. They might be working from home somewhere else. They're going to go through and sort through all these fee review requests. Probably an even more boring job than talking about fee reviews is doing this process. So they're going to look at the bill that came in. They're going to look at the request that was submitted by the provider. They're going to compare it to whatever their repricing standard is. And we'll talk about the one for pharmaceuticals in a minute. And they'll generate the next step, the fee review determination. That's about it. If you have a UR request pending, they're not always aware of it. The beauty of the state administrative machine, you would think if the provider submits a fee review request and there's already a UR request pending, so we talked about that's going to toll the fee review, you would think that the fee review administrative folks would just look at the system and say, oh, hey, utilization review, we're just going to sit on this. They don't always see that. Frankly, I don't think they can see that. So if you're the adjuster and you get that notification that there's a fee review pending, you've already requested utilization review, let them know. Give them a response and say, there's UR pending, and they should note that in the next step, which is the fee review determination. Was there a question from the Ethernets?
No, it was another individual who had the same situation that you just addressed, and
Okay.
we were just commenting about how it doesn't seem like a fair process to have to file a petition when you never received a bill.
This is like when you go to the aquarium and they bring out the stingrays for the kids to pet, and it's like the interactive portion. I can see your excitement. This is an actual fee review determination. This is what you're seeing here, folks. I mean, you came here today for Lee's excited. Everybody's excited. What we're looking at is what they're actually going to pump out. It's going to be called a fee review determination. They're supposed to issue this. The Bureau is supposed to issue the fee review determination within 30 days. Historically, they've been pretty good at that. I think we probably screwed them up with the Federated decision that I'll talk about in a minute. If the amount is contested, the fee review section will identify what's allowed, and they'll provide the calculations. And that's what you're seeing here. The reason I put this up here, and I understand people in the back might not be able to read it, it doesn't really matter because the point is it's not very descriptive, is it? Even if you read, so what we're looking at is every line there is a diagnostic code and a billing entry. And the number on the right is the workers' comp allowance. So the first two are 0, the third one is 120. They're telling you that's what you paid. It tells you the amount billed on the left. It doesn't really matter what was billed. All that matters is what they're telling you to pay. And you can look up all the diagnostic codes on the left. They usually start with a 9. On the right side, there you see some dates all the way on the right. Next to that, there's a reason code. There's A02 and K10 and M59er and all kinds of stupid codes. What does that mean? At the bottom of the fee review determination, there's a summary. It says reason code descriptions. And all of those little letter combinations, A02 and K10, they're going to correlate to a description that they give you. This is, in theory, where they would explain to you in painstaking detail why the bill was reduced, why you were ordered to pay more than you thought you should have paid. What I think you'll see is that these are just like you guys have to deal with drop-down menus a lot in picking up a claim and describing an injury. The folks in the fee review office do too. So a lot of the descriptions are simply as the service has not been properly billed. Okay, we don't know what that means, but we're going to fight over it in front of a fee review officer. So it's a weakness in the system. I don't think it's intentional, but that's why we end up before fee review officers a lot, because we don't really know what the Bureau is trying to tell us in their coding, because they're not descriptive codes at all. Any questions about the first couple steps of the fee review process? You guys good? You awake?
Yeah.
Okay.
All good.
All right. So now we're going to go before an administrative officer, fee review hearing. If you get your fee review determination and you decide, you know what, that doesn't seem right. When I put this through my repricing system, it said $100 and the bureau says I owe $900 just for this one line item. Your remedy is to file for a fee review. Fee review hearing, it's called a fee review hearing request. You have to do that within 30 days of receipt of the fee review determination. You can do it. I think you can still do it on paper if you're so inclined. I wouldn't recommend it, but you do it through WICAS traditionally. And that's going to be assigned to a fee review hearing officer. A fee review hearing officer, at one time when I first started doing fee review, for a while, it was actually work comp judges. They would sit in dual roles. So the comp judge would do their comp cases, and then they'd have some fee review hearings afterwards. They've since hired dedicated fee review officers. They're administrative officers who only do fee reviews, and it's going to be assigned to them. They're not under the auspices of the Office of Adjudication. They operate separately. So it's a completely separate process.
They're under the BWC as opposed to the adjudication office?
Yeah.
Okay.
And we'll get to why that's important in just a second. So we have a lot of small issues that we litigate before fee review officers. The context is such that I think a lot of you know that most comp hearings now in Pennsylvania are by video. Some of the judges will testimony live. They'll do SCAR viewing. I love SCAR viewing. They do that live, but most of the stuff is by video. Fee review, I've done a couple live fee review hearings on very difficult cases, but by and large, we're doing everything by video for the fee review hearing. So in that setting, it's not that much different than the comp judge. There's going to be a court reporter. There's going to be a fee review officer. There's going to be usually the two attorneys representing the provider and the payer. What are we going to fight about? We might fight about the fact that the bill was, ordered to be paid at $100 and you've always paid it at $80. Typically, we'll resolve those. Sometimes we won't. As dumb as it sounds, if you're getting, 2,000 different bills across your system, across your whole claims community, where it's being billed at $100 and you've always paid $70, that money can add up. So in certain situations, it can make sense to fight over what might seem like a smaller bill because the cost savings across your whole claims is going to make a big difference. What else are we going to fight about? We're going to fight about issues of self-referral. That's become more of an issue recently. It started with the compounded pain claims, but the argument there is that providers who are owned by doctors who are prescribing to that provider, so a pharmacy, for example, if I'm a pain management doctor and I tell you to go to Jim's pharmacy to get your opioids, and oh, by the way, I'm Dr. Jim and I own the pharmacy, that is arguably a prohibited self-referral. So we'll fight about that. We'll fight about all kinds of other issues. We will do testimony in front of the fee review officer. Again, it's typically by video. We'll submit briefs. I do ask them to sign subpoenas. They're very reluctant. They don't like getting into that type of practice, but we do a little bit of forms practice. And that's really about it. It's not altogether different than litigation before a workers' compensation judge, except for the fact that it's not a workers' compensation judge. And by and large, the claimant's never going to be involved in a fee review hearing because they don't really care whether you're paying $100 or $80. They just want their medications. So,
Jason, I have a question.
Yes.
Maybe I'm getting a little ahead of ourselves, but I'm talking more about a decision from the fee review hearing officer. Can the fee review hearing officer award unreasonable contest fees either under Section 440 of the Act or under case law like Lorino, or do they not do that?
Nobody has given them that idea. Thank you, Lee. I don't think they would be capable of doing that. I think unreasonable contest fees, in my interpretation, are come from the idea of attorney's fees. So a claimant's attorney's fees. In the fee review process, the claimant's not involved. The claimant's counsel fee is not at issue. So all of the people that I deal with, all the people representing providers, they have their own fee arrangement that's not approved by anybody. So they could get 50% of the amount awarded. They could get $1 an hour. However that attorney wants to be paid, that's their own decision. That's between them and the provider. And nary is it my responsibility or the fee review officer's responsibility to get involved. So I've never seen counsel fees awarded. I'd be surprised if that happened. They do award interest. That's very common. It'd probably be unusual not to have interest awarded if there's a payment awarded. But that's about it. And I think we'll get to.
I have a question.
Yes.
All right, so we know that now we are.
You guys, you're not going to get a spot on the bracket after.
My team has not been taken yet, Gonzaga. So I know that we're seeing a lot of claimants attorneys taking a 20% fee on medical. So if a bill after repricing is $100, $20, 20% goes to claimant's attorney, the other 80 goes to the provider. Are you seeing that having an impact when you're doing the fee review and now you have a provider's counsel who's also trying to get a piece of the puzzle?
No, I have not seen that come up in fee review at all. I don't think it would be a dispute over the amount owed. It would be a dispute of the payment received. So I think it would be quickly remedied if the, obviously, don't, adjusters, payers out there, don't be paying 20% counsel fee on medical unless you have that fee agreement from claimant's counsel. So as soon as you provide to me the fee agreement between the claimant's attorney and the claimant, or the claimant's attorney in some cases and the provider, I'll submit that to the fee review hearing officer and say, look, the amount is $100. Who's getting 80 and who's getting 20? That's not your issue, fee review officer. So I haven't seen that. I could foresee a world. Have you guys seen a lot of that, of the medical bills being paid 80-20?
I just see one firm in particular that's pursuing that. Most judges don't like it and they give the firm a hard time. And I think that's why all the other firms have backed off. But you guys could probably guess the name of the firm that I'm speaking of. Lee, are you seeing that?
Same thing, one firm pursuing, mostly one firm pursuing payment of medical bills as part of their fee.
Yeah, and as a business practices issue, that's also why you guys are here, so I can tell you how to run a business. I don't think it would behoove you as a claimant's attorney to start doing that with a provider who you don't have a good relationship with. If you start stealing 20% from, Dr. Jim, who's doing the neck surgery on your claimant, it's probably not going to go well for you. I would expect it's more common with a provider who they send a lot of claimants to. And I suspect that it's already known in advance by the provider that money is going to be coming out. I haven't seen any disputes about it between the provider and that unnamed law office. I don't know if you guys have.
I have not.
Yeah, so I think that everybody's aware of what's going on there between the attorney's office and between those providers. So with regard to the decision, 90 days is what the fee review officer has as a time limit to issue the decisions. I think the comp judges actually are supposed to have a theoretical deadline to issue decisions. I don't know that it's ever enforced, but
I mean, the comp judges are clearly getting better at getting decisions out faster. For those of us who've been doing this for a long time, it could take forever to get a decision. They seem to be moving pretty quickly now.
I think they get dinged if it's not issued within 6 months. That's like the absolute threshold. I think that they have a goal of getting it out sooner, and it starts to flag different individuals. But once it gets to the 6 month, I think it flags the highest of their bosses.
yeah, and I think you'd be surprised at the length of some of these fee review decisions. They can get really, really into the weeds on this stuff. And I think the reason is, if you're a workers' comp judge, I love all the comp judges, anybody sneaking in online, but they see a lot of the same cases, right? Like you see a lot of it's doctor versus doctor, or it's out my back, and it's been out my back since I was 10, or it's only been out my back since I had a work injury. And this judge has seen this dispute 100 times. They probably already have proposed findings template they can grab from. When we actually go to decision with the fee review officers, it's usually for a reason. And so it's usually over something that it's very intricate, and they really have to spend time because they don't have a template. They don't have anybody else they can steal from. They have to write their own content, so to speak, which makes for great appeals, but it also makes for long decisions. One thing I did skip, and I apologize, which I think is incredibly important, is the burden of proof. And I think this is the biggest issue. If there's anything I could fix about fee reviews, it would be this issue. The burden of proof before the fee review officer is always, always, always on the insurer or the employer. It's always on the defendant, even if they're not fighting about how much was awarded by the fee review department. So the inevitable situation that happens is a bill comes in, you pay $50. It goes through fee review. The fee review folks say, you need to pay $100. You say, okay, I'll pay $100. So you pay the $100, life is fine. The provider's not happy. So they say it shouldn't have been $100, it should have been $150. And they challenge that award of $100. When you go before the fee review officer, it's now your responsibility to prove to the fee review officer why it was $100 in the first place. So you have to prove why the fee review department came up with the number that they came up with. As a practical matter, I don't think most of the adjusters spend their day going through diagnostic codes and repricing guides and looking at this incredibly boring stuff. So as soon as we get a fee review, I'm going to reach out to you, the adjuster, the claims manager, and say, hey, here's the issue. This is what the Bureau said was awarded. We need to find somebody that's either within your TPA system, somebody that's an outside vendor that can, if I need it, they can come in and testify and say, that's why it's $100 and not $150. So it can be very fact specific. We can require testimony from people that don't want to testify and that aren't always asked those questions. So I think the burden of proof issue is really significant. Frankly, I think it's why we settle a lot of fee reviews, because people don't want to go through that admittedly painful process. So the decision comes out, you like it, you don't like it, it's long, it's hard to read. What are you going to do? You're going to appeal. Lee, this is getting back to your question about office adjudication. The fee review section, to my knowledge, is the only workers' comp adjacent administrative body within Pennsylvania that appeals directly to the Commonwealth Court. We don't go to the Workers' Compensation Appeal Board. We're not under their auspices. Good and bad. The good is that, I don't know if there's any appeal board people on the good is that it cuts out that process. Because I think, as everybody knows, if you have a really heated legal issue, you're usually not going to stop at the Workers' Compensation Appeal Board. If you think you're making new case law, the appeal board can't do it anyways. So you're going to save a year and a half or whatever it might take to get through the appeal board process. You're going to go straight to the Commonwealth Court. The bad of it is, I don't know if anybody in here has submitted any Commonwealth Court briefs lately. They have not moved with the speed of lightning to catch up with the digital world. So you still have to submit, 15 paper-bound copies of everything you send in, and it has to be, a certain type font and spacing. It's probably more expensive to litigate a Commonwealth Court appeal, and they don't mess around. The appeal board it's a little bit informal sometimes when you have appeal board arguments. The Commonwealth Court does not like to be referred to as informal. They take themselves seriously. So it can be a costly process. A lot of times that's why people don't decide to take up appeals. The other good side of that is that we make a lot of case law because we're going straight to the Commonwealth Court, and they're going to have to decide it. So there is a lot of case law out there that I think if it were in the comp realm, the regular WCJ realm, we wouldn't get that far along. Any questions about appeal process so far? No? Any questions about fee reviews? Anything online?
No, you're good.
Are most of you guys who are medical bill payers outsourcing this to a third party vendor? Yes, no.
Yes and no.
Yes and no. Okay.
Yes.
We do a lot of work in Jersey as well, and we're seeing a trend.
I don't know if that,
We're seeing a trend with neuromonitoring.
I think we might just.
you can turn that off.
Thanks.
We were trying to get the micro, I promised Eric I would bring this up and I completely forgot. The good folks on the internet, they can't hear when the audience is talking because you guys don't have a microphone, but I can certainly repeat whatever you have. You're talking about neurostimulators? The question was about neuromonitoring, extending beyond my limited medical knowledge. I would assume that is this monitoring brain activity during a spinal surgery? So it's probably assessing. So it's an ongoing EMG during the spinal surgery to make sure that you don't cut too far. And it used to be billed pretty uniformly, a couple $1,000, $5,000, $6,000, $7,000. The bills have increased exponentially to $40,000, $60,000, $70,000. I don't think I've litigated that issue. We litigate a lot of spine cord stimulator issues because what a lot of the ambulatory surgery centers are doing is they're billing for the implantation at every single level for a spine cord implant when it's supposed to be one bill to do all the levels. So we fight about that a lot. With regard to your question, though, do you deny it or do you pay it? I would recommend you pay it with a reason. So whatever vendor you use, whoever you talk to, whatever resource you have, talk to them and see what they have. Can they look around comparatively? Can they go outside the comp system? Because if it is a usual and customary issue, which it probably would come down to, then you just have to provide your proof of this is why we're reducing it. This is why we're paying $10,000 instead of $40,000. Because unfortunately, there's not a lot of governors. There's not a lot of limitations on those bills. I won't say they can put whatever they want, and there is supposed to be a limitation, statutorily, but I don't know how well it's followed because you do see a lot of bills. Everybody knows this. If you have a relative that goes in the hospital, they get an emergency room bill sent to their house and it's $150,000. And they say, no, thank God for my insurance. It was $150,000. We all know the insurance company's not actually going to pay $150,000. So it's the same thing, but I would skew away from denial because I think that's really leaving it up to the provider to control the conversation. And what they're going to do before the fee review officer is it's still our burden. So we have to go before the fee review officer and say, it should have been 6,000, not 40,000. The immediate response from the other side, maybe with less snark, is, well, you didn't pay anything. So, it doesn't give you a good starting point with that fee review officer. Is there another question?
But thank you for bringing the issue up, because I have not seen it in Pennsylvania. No one's raised that as an issue for me, and I think that they would, if it was a $40,000 to $60,000 bill, and would have heard about it in Pennsylvania. But it's only a river away. I mean, the river's right there. So, yeah, thank you for bringing it up. I'm curious about this going forward.
Okay, so let me just run through what the misnomer as hot topics. These are what we deem as exciting in the fee review realm. I'm not going to go through individual cases, but I'll tell you what they say. The Armour case, the Workers First case, essentially said that you can't settle around a provider's outstanding bills. So you can't put in your C&R agreement, yeah, I know Dr. Bob has a bill for $20,000, but the claimant agrees we're never going to pay Dr. Bob and he can have a nice day. We didn't always do that in that sort of forthright manner, but there were situations where we agreed that certain treatment wasn't reasonable and necessary, or that it wasn't causally related to the work injury. And lo and behold, that treatment happened to be really expensive. The Commonwealth Court has found in more than one case that you can't do that. You can't use the C&R to contract around exposure that you might otherwise have vis-a-vis the work injury. Another recent case was the Philadelphia Surgery Center case. And this gets to Lee's point. He asked about unreasonable contest fees. No, the fee review officer, in my assessment, they can't award unreasonable contest fees. They can't even, and this is what the Commonwealth Court held in this case, which I believe is before the Supreme Court now, they can't award reimbursement of overpayment. So if you got that bill and you paid $150 and the fee review section came back and said, well, it should have actually been $100, you overpaid by $50, but the fee review officer can't give you an order to pursue that.
So you can't pursue it against the provider, and there's no supersedeas fund reimbursement.
I didn't say you can't pursue it against the provider. I said that the fee review officer can't award reimbursement. Are there other remedies to seek against the provider? I think they could be. I don't know that it'd be a comp petition, but I think certainly there's other ways to pursue that. But the fee review officer, which to his credit, he tried to do here, and the Commonwealth Court shot him down. Other recent case law is about the relationship. I don't even want to touch on this really. The relationship between utilization reviews and fee reviews. So forever and a day, the standard was that utilization review was where you thought about reasonableness and necessity, and it wasn't really about causal relatedness. The idea was that you're agreeing that this treatment is causally related to the work injury, but you're fighting about whether it's reasonable and necessary. So through the fee review arena, and I explained that fee review comes up through a different side than workers' comp judges, there was case law that percolated that said that if you didn't submit for utilization review, then you've waived the issue entirely of causal relatedness. Therefore, you have to pay for the bill. That's contrary to what we've always held in comp, which is that if you don't submit for utilization review, you can still contest causal relatedness, and you do so in the context of a penalty petition. So I have an accepted right shoulder injury. I start treating for my left knee. The left knee bills come in. You say, we don't have a left knee injury. You can do what you want to with your left knee bills. And typically that claimant would file a review petition to add in the left knee. They file a penalty petition for non-payment. What the fee review decision tree said was, again, they're concerned about the provider. They're saying the provider's out of court on this issue. So if the claimant neglects to file the review petition or the penalty petition, how is that provider ever going to get paid? So a very bad series of cases came up that said, hey, when we're talking in the fee review arena, if you haven't requested UR, then you've agreed that there's causally related treatment that you might have to pay for. Fortunately, last year, I think early 2022, from the comp side, again, from the other side, the workers' comp judge side, contrary case law came down, which kind of restated the norm. So as of today, there's arguably two different controlling case law realms. There's the fee review area where a provider could argue that you needed to submit for utilization review, and there's the comp area where it's just as it's always been. This is the wrong slide. So
That's the prior.
Yeah, it was a prior side. Do you have a question?
So Jason, how are the hearing officers reconciling these conflicting cases? I had one give me the same grief regarding the Workers First Pharmacy case recently, that we hadn't filed a utilization review. So how are they generally reconciling the dispute between the cases?
It depends on how aggressive the defense attorney is. I would, the Skay Borgeson case is the second one that I referred to, the more recent one.
Right.
I would argue that it's controlling in the fee review context as well.
Okay.
It's really gonna, and then it's gonna divert as it always does. What sort of bills are at issue? What's the cost of the treatment? What I've been telling my clients is, you know, you don't want to start URing everything. I'm not telling you to UR the left knee now when it's not accepted. But if you're talking about, you know, low back and you know, low back, maybe you have an accepted low back strain and it's a treatment specifically to the L5 level, you might want to look at UR there, even if you haven't accepted the L5 level injury. Any other questions on that line of cases? So we'll wrap up on the Federated case. The Federated decision came out January 2nd of this year. The quick history behind Federated, and I want to make sure I'm okay on time. 10 minutes. So circa 2015, right around when everybody started getting excited about medical marijuana in Pennsylvania, pharmacies in Pennsylvania began increasingly prescribing topical pain creams. It's a pain cream you rub on your shoulder or your knee or your elbow or your back. It gives you a fuzzy numbing sensation and supposedly makes you have less pain. The issue starting around that time was that these tubes of pain cream were being charged at about $5,000, $6,000, $7,000. It became an epidemic. Everybody was getting pain creams and they were charging incredible amounts of money. We went through various ways to attack this issue. Initially, we noted that the initial creams that were prescribed, they had like a generic name. So it was like Federer's topical pain cream. And it would come in and that's all it would say. It would say one line item, Federer's pain cream, $5,000. We properly instructed our clients to deny those bills because we don't know what's in the magical Federer pain cream. That was a good idea and a bad idea. It was a good idea because it took care of the bills initially. It was a bad idea because the pharmacies decided, all right, well, if you want to know which ingredients are in there, I'm going to pick some really expensive ingredients. And so we would now get bills for compounded topical pain creams with 5 or 6 different ingredients, and they would justify, you know, based on the price, a very high amount. So you're talking $6,000 to $7,000 broken down amongst 5 to 6 ingredients. What were those ingredients? How were they repriced? They're repriced in Pennsylvania based on average wholesale price. So average wholesale price, I think a way to delineate it, to think about it probably in past terms, is kind of like the sticker price of a car. So 10 years ago, probably not today, you go to a car lot and you look at the car and say, hey, this is a great car. And there'd be a sticker on the window and it'd say $25,000. And the pushy car salesman would come out, apologies to any car salesman or saleswoman, and they'd say, you know what, we can get this to you for $20,000 today. That's just the sticker price. Don't worry about it. We'll sell it to you for less. Less of an issue today, but I think it's fair to look at the average wholesale price as the sticker price. Unfortunately, in Pennsylvania comp, that average wholesale price, that sticker price is the standard by which we've always repriced medications. So with the pain creams, entirely coincidentally, the ingredients that were selected for the pain creams had a very, very high average wholesale price. They had a very, very high sticker price. They had a very, very low acquisition cost. So it did not cost a lot of money for the pharmacies to buy these ingredients in the pain creams, but their sticker price was much higher. So the dealership was buying the $25,000 car that's on the lot for $5,000, giving you a deal for $20,000. Congratulations. So that's what was going on. We raised this issue. We attacked the pain creams initially from the self-referral. You mentioned the doctors potentially owning the was it the neurostimulator, the neuromonitoring company. That's a self-referral issue. We saw this same thing here, surprisingly. A lot of the same doctors that were prescribing these topical pain creams, which for the most part are lidocaine based and you can buy for $20 on Amazon, they were prescribing them and they also had an ownership interest in the pharmacies that were selling them for $7,000 each. So we attacked that issue. We attacked the self-referral issue. We made a lot of progress. There was a lot of publicity and a lot of the doctors backed out, but not all of them. So we also raised the issue that the average wholesale price, that sticker price that the Bureau has been using since the beginning of time, is not the actual average wholesale price of these prescriptions. It's not what it actually costs if you went out to wholesalers and said, I need to buy a gallon of these ingredients. How did we know that? We're not that smart, but we're smart enough that we can read. So the standard that's always been used for average wholesale price in Pennsylvania and in a lot of states is Red Book. There's a compendium called the Red Book. It was initially published by a company called IBM, which I don't think is a computer IBM. The book itself, the IP has been sold several times. It's now owned by somebody else, but it's a very well-known medical compendium for pricing index. In the Red Book, on the second or the third page, there's an asterisk, and it says that the average wholesale prices referenced in this guide are not the actual average wholesale prices that are used out in the community. So they admit in their own publication that they're not actually using what you would get if you went out and surveyed people that are selling at wholesale. We raised that issue back in 2020 initially with the pain creams, and we did it, I won't say sua sponte, but we did it theoretically. We didn't present specific evidence of a different average wholesale price. We just said, hey, look, this standard you're using for average wholesale price, if you actually read it, it says that it's not the actual average wholesale price. We went to the Commonwealth Court on that issue. They didn't completely laugh us out of court. We lost. I'll admit we lost because we didn't present that evidence that I'm talking about. But basically what the Commonwealth Court said was, that's interesting. You're right. The book does say that, but that doesn't mean that there's a better standard out there. So just because they're admitting that their standard's not perfect doesn't mean that we have to throw it out, because honestly, what's the alternative? So we regrouped, we lived to fight another day, and we came back about 2 years later, and we offered an alternative. It's called NADAC. There's controversy over how widely used it is and how accurate it would be, but the expert that we got said, you know, why don't you use this NADAC standard? It's inevitably cheaper than Red Book average wholesale price, and we think it's an accurate measurement of what these ingredients are selling for at wholesale. So we went before the fee review officer with our expert, with our learned arguments, with our confidence and joy, and he destroyed us. He shot us down. He wrote a 40-page opinion essentially telling us not only how dumb our argument was, but how dumb we were for bringing it. It's a good decision to read if you want to see somebody just get excoriated. Lucky for us, the Commonwealth Court disagreed. So we took it to the Commonwealth Court. They sat on it for about 6 months. They obviously, before the Commonwealth Court, we were arguing for this NADAC standard. We're saying Red Book's not right. Here's the alternative. If you read the language of the act, it says it has to be actual average wholesale price. Red Book says it's not actual average wholesale price. So please pick our standard. The Commonwealth Court, they didn't do that. They threw out the Red Book. They said, you're right. We agree with you now that Red Book is not the standard for average wholesale price. But you're wrong, because the fee review officer said that NADAC was not either. So they remanded this entire issue, which again covers the payment for all prescriptions in Pennsylvania workers' compensation cases, back to the fee review officer. And they told the fee review officer to stay the case until the Bureau comes up with a new standard. So that's where we are as of this month. The pharmacy has appealed. They request reconsideration from the Commonwealth Court, and they've also appealed to the Supreme Court. The Bureau has, as of today, not acted on the issue. They are waiting to see what the courts do, and that's where we're at. So that's what happened with Federated. So there's obviously a bit of uncertainty with regard to payment of prescriptions. I don't personally recommend that you stop paying for all prescriptions, but I think you should be cognizant of what you're paying and why you're paying it, more so now than you were before January 2nd. Is there a question?
The burden of proof is still going to be on the employer carrier if the provider doesn't like how you pay them.
Lee, if there's anything I could change with regard to fee reviews, it would be to put the burden of the proof on the challenging party, because it makes for an impossible situation. I think one thing that I might start doing is to subpoena the fee review people and have them testify about how did they get with the number that they got with, because otherwise it's very, very hard for our clients to, find the person who's best there to speak about why the number is 100, not 150. There was a question back there. It's a very fine line, and I wish Dan Siegel's the guy representing the farmers. I kind of wish Dan was here to disagree with me. The Commonwealth Court did not undertake a very piercing analysis of NADAC, because I told you the fee review officer spent 40 pages telling me how dumb I was. He told us our expert was dumb too. So he never undertook an assessment. He didn't sit down with NADAC in one hand, Red Book in the other hand, and say, okay, this is right, this is wrong, this is how they compare. He found that our expert wasn't credible on his face. So is there a world where you could still use NADAC and it could be proven correct? There probably is. I think there's other weaknesses with NADAC that are becoming apparent. I don't think it's wrong right now because there is no standard right now. So if you're paying pursuant to NADAC today, it's always going to be a lower number than Red Book, but you have to do so with the realization you might be ordered to pay more at a later date. Any other questions?
With interest.
Yeah, with interest. Anybody else on fee reviews? I don't know if you're still there, online people. I'm looking at you directly. There was a question about the status of the Federated appeal. Did they deny or accept the appeal? There's a petition for allowance pending. They have not ruled on that. They're not going to rule on whether they take the appeal until the Commonwealth Court rules on whether they're granting a stay of the order. So once Commonwealth Court rules, it'll be up to the Supreme Court. I'm incredibly biased, and I've said this in front of Dan, I don't know that it's necessarily a case the Supreme Court would take. As significant as it is, it's not really constitutional or due process type issues. It's really a boring pricing issue. So I don't know that the Supreme Court will be necessarily automatically going to take it. The tall gentleman in the back, always being mindful of the audience. I was told initially that SWIFT had stopped payment on prescriptions in full. I don't know if that's accurate. I don't know that we rep SWIFT anymore. I don't know that I would use that as a guidepost, to be honest with you. That's the only one I heard. I haven't heard about UHF, but I was told that they were going to do a 30-day hold on prescription payments. I mean, the reality is, folks, you still have a responsibility to pay for prescriptions in Pennsylvania, number one. Number two, the system has always been set up as a negotiating terms. You can always negotiate prescription bills. Nobody does it because it takes a lot of time, but you can negotiate any prescription bill you get. You can negotiate with the provider, say, why don't I give you $28 on this one? And they say, heck, why not? It's Thursday. And they take the $28, you're done. So the way it's set up is after you do that negotiation, if you can't come to an agreement, that's when they file for fee review and you go through the process. So if Swift's doing it, good luck to them. But I think they're going to be hit with a lot of old pharmacy bills, in 6 months, where they're going to owe not only the amount of the bill, but as Lee mentions, interest. Anybody else? I don't have a summation speech for you good folks online, but I appreciate you tuning in with us today. We do a lot of online content. So, and for the people in the room, if you ever see any of the emails, we do a lot of webinars and that sort of thing. There's a great podcast that I listen to faithfully. So we've got a lot of content that's pretty good. So pay attention and join when you can. And thank you again to the online community. If you want to drive down and come to lunch at City Tap, the more the merrier. But that'll be it for the online portion of the program.